PBI started these webinars about a year ago and really found a lot of benefit and feedback through our clients to share insights that we have through our partnerships with various other agencies and organizations to do co-branded webinars as well. So this is a continuation of that series. Today we're going to talk through annual funding notices or annual funding and other retirement plan notifications and what you need to know. As we think about this event, this is the season right now where annual funding notices are starting to kick up. And so PBI and Morgan Lewis will take the next 30 minutes or so to talk through really the retirement plan notices, locating plan participants, and then always a fun topic, 2022 predictions, if you want to shake the old glass and see what happens. And then we'll have a couple of minutes for questions and answers at the end. So before I introduce our panelists, I'd like to introduce who PBI and Morgan Lewis are for those who might not be familiar. PBI is the industry leader in finding missing participants and beneficiaries, as well as providing the only full death audit solution, CertaDeath. This past summer, PBI also introduced CertaCensus, which is a proactive pension management solution. And at the end, we'll include some contact information so you can reach out to the PBI folks for more information. Morgan Lewis provides high-quality litigation, corporate, employee benefits, labor and employment, as well as intellectual property services to clients across the industry, sectors, and regions around the world. My name is Mike Schoonveld, and I'm your host of this call. I'm the National Director of Sales for PBI, and I work with our clients across all segments, from pensions in the corporate, government, and union space, as well as administration clients, and then also in the insurance and financial sector. I'm joined by one of my colleagues, Mike Irey. Mike Irey is PBI's Director of Operations. Mike has over 15 years of experience with data and records. Most recently, Mike worked in the life insurance industry, managing and servicing thousands of portfolios of life insurance policies owned by financial institutions. And over his career, Mike has successfully led teams, implemented time-saving document generation systems, and produced detailed reports for clients. Said another way is Mike really appreciates the quality of data and puts a high focus on that quality. Carly Gray is an associate attorney with Morgan Lewis. Carly counsels employers and employee benefit and executive compensation matters. She advises on qualified and non-qualified retirement plans, health and welfare plans, and executive compensation arrangements. Additionally, Carly counsels clients on the legal issues arising under ERISA, the Internal Revenue Code, the ACA, HIPAA, and securities laws. And with that, let me turn it over to Carly Gray.
Great. Thanks so much, Mike. So we wanted to start today in our brief conversation, and thanks for being here to join us for it, with some examples of periodic notices to plan participants. So we've listed several on the slide here. We only have a half an hour, so we're going to highlight two of them in particular for our conversation today. As Mike mentioned, it's annual funding notice season, so we wanted to do a quick refresher on that and share some guidance that is relevant to those that can be helpful as you embark upon that process. And lifetime income illustrations, which are a new requirement under the Secure Act for periodic pension benefit statements. But there are also a number of other notices that plans should provide, whether they be defined contribution plans or defined benefit plans. And so there are a lot of things to consider that can be relevant to those types of notices that we're going to talk about briefly today. So with that, let's turn to the annual funding notice. So the annual funding notice is really the primary communication to defined benefit plan participants which shares the information about the financial condition of the plan. You can see here the different things that should be included in that notice. And it's kind of a substitute for plans that are defined benefit pension plans for their summary annual report generally. With respect to the summary annual report that you send for other plans, it's sort of a regurgitation of things on the 5500. This one's a little more focused with respect to the funding status of the plan. And you do actually get it out if you are a PBGC insured plan. So, governmental or church plans would still have to arguably provide SR. This information is, it's kind of lengthy, but it's fairly automated because there are model notices in the rules. Next slide, please. And so, for defined benefit pension plans that are providing this notice, we would point you to the Department of Labor regulation appendices, because it basically outlines what this should look like. One thing I would say is, what we've noticed from a litigation perspective is if there is a model notice out there or model language that's been provided by regulators, it's generally a good idea to use it. We haven't seen a lot of litigation in the annual funding notice context, but we have in other types of notices. COBRA notices, for example, come to mind. So you always want to be a little careful when you deviate from any sort of model language. So it is annual funding notice season, and the timing here varies a little bit depending on the type of plan that you have. So if you're a large plan, which is a plan with more than 100 participants, you have to provide it not later than 120 days after the close of the year. And so for a calendar year plan, that means at the end of April, you're going to be aiming to get these out. For smaller plans with 100 or fewer participants, you typically don't need to provide it until your 5500 filing is due, which is generally, again, for a calendar year plan with extensions included, going to be October 15th of the year that the notice, following the notice that it relates to. And what we would say is, that it is a season because, you have to provide these notices towards the end of April, but you should probably get started now for some of the reasons we're going to talk about a little bit later, thinking about how you get your data in order and other things so that you can make sure these notices are being provided effectively. So this notice goes to participants and beneficiaries and alternate payees who are receiving benefits, as well as for collectively bargained plans, the union that's associated with the plan or the collective bargaining organization, and for those plans as well, the multi-employer plan employer participants. You also have to provide notice to the PBGC. I would say on that one, it's interesting. You have to provide it automatically if you're a single employer plan with your underfunding basically of 50 million or more within 30 days. For other plans. So if you've got less than $50 million of underfunding, then you just have to wait for the PBGC request. And the PBGC notice can be provided by mail or email. For multi-employer plans, you can also use an online filing portal for the notice to the PBGC. And in fact, the PBGC really encourages plans to use online notice as much as possible rather than mailing. So the annual funding notice hasn't changed tremendously in the past few years in terms of its content, but some of the issues related to how it's delivered and things have. So we're going to talk a little bit about that in a minute. So now we'll shift to the lifetime income illustrations. And this is a new requirement for pension benefit statements under the Secure Act. And the Secure Act, of course, was enacted in 2019, I believe now. Time flies during COVID. And it hasn't actually, this may not be something that you've seen yet because it's really going to be implemented more this year. So we want to start with some general background. And it's really designed to reflect the fact that there's been an overall shift from the provision of retirement through defined benefit plans to defined contribution plans. And these lifetime income illustrations are meant to show what an account balance would be payable in the form of an annuity. And in general, the thinking there is that some participants may be misled by merely looking at the lump sum in their plan balance, and they may think that amount will last them long through retirement, and it may look like a really big number. But then when you break it down, in the form of annuity, they get a more realistic picture. Many plans and record keepers included notices like this in their pension benefit statements. So, I guess just real quick point, pension benefit statements apply to defined benefit plans as well. The lifetime income illustration is only applicable to individual account plans, so like a 401k plan. When it comes to providing that illustration, it makes a lot of sense, right? Because the defined benefit pension plans typically express their accrued benefit in the form of a constant stream of payment. Whereas, these individual account plans, they have more of the lump sum. If you've been providing this information in your pension benefit statements historically, this is going to be a shift because you have to use very specific assumptions when preparing this information. And so, as indicated here, you have to provide an illustration of what an annuity might look like with the assumption that it's based on the current value of a participant's account when the illustration is prepared, which would not include any projections for future earnings or contributions. Obviously, that is nobody's goal. There's typically an expectation of earnings or contributions, so this may kind of deflate the estimate, for some individuals as compared to other estimates that a lot of providers and record keepers were using beforehand. You have to use the 10-year constant maturity treasury rate as of the first business day of the last month of the statement period to calculate these payments. Really specific and nuanced on this one, just because I have seen in some of the draft statements that the interest rate is not right. This rate is meant to be used to approximate what the insurance industry uses to price immediate annuities. And, similarly, you've also got to then incorporate a mortality table to convert a balance, and you would use the same gender neutral mortality table that's used under Code Section 417E3 for lump sum cash outs in defined benefit plans. So for those of you that sponsor both types of plans, it would be sort of familiar. And the assumption is also that payments will start immediately. And this is regardless of the participant's age. So they may not even be close to retirement age, but you would still show that illustration right away. You also have to assume that the participant will reach at least age 67, unless the participant's already older, and then you have to give the illustration as of their current age. And so ultimately what you're going to be showing in this illustration is the benefit in the form of a life annuity and a joint and survivor annuity. And for plans that already offer in-plan annuities, there are special rules about how those are carved out. You don't use the same assumptions for those, but we won't get into that today. That's somewhat less common. So as you can see, there are some limitations to how useful this information may be because of the nature of these assumptions, which may not be realistic in many instances for participants. So this, again, it applies to individual account plans like 401k plans, not defined benefit plans or anything like that. Much like the annual funding notice, there is model language that's in the DO rules. So we wanted to share that citation with you so you can see it. It is not in the same format of the model notices for the annual funding notices. It's more like paragraphs, so it takes a little more work to put it together. But it does make it helpful, and we would certainly point folks to that with the litigation comment I made before. And one of the things that's been really challenging with these illustrations is figuring out the exact timing. So as I mentioned, this was part of the Secure Act, and the requirement for the rule was basically that the illustration, the rules need to be issued within a time period that basically resulted in a September 18th, 2021 interim final rule. And so for any illustrations that are included in pension benefit statements after September 18th of 2021, this has to be included. So what does that mean? Pension benefit statements are furnished in a number of ways, and it's partly a function of how your plan is set up. So does your plan allow participants to direct investments like a typical 401k plan, in which case you have to give quarterly statements. And so for a quarterly statement, what that translates to is your first lifetime income illustration has to be included in the quarterly statement up to the second calendar quarter of 2022. So that's going to be like June 30th of 2022 for a calendar year plan. So you're talking about this summer. By this summer, you should have done one of these illustrations. For a plan that's a defined contribution plan without the opportunity to direct investments, which is a little less common, you would have an annual disclosure obligation. And so those would typically be due for a calendar year plan around the time of the annual return for the plan, including extension. So again, that's your 5,500 deadline of October 15th of 2022 that you would see for them. And just as a reminder for those of you who don't have individual account plans, for defined benefit plans that do not need to include this illustration, those notices are typically only provided once every 3 years, or you provide an annual notice of availability. So don't panic if you're wondering why you don't do a quarterly statement. The group of recipients for these is much more narrow. It's for participants and beneficiaries, which makes sense. This is really like their statement of their account, right? You wouldn't give that to a union or a employer participant or the PBGC. So with that, let's talk a little bit about how you get these notices to participants. And when I say these, I mean kind of some of the examples that we just talked about. So a lot of notices historically had to be mailed, but in 2020, the Department of Labor issued guidance to allow more liberal usage of electronic disclosures. That rule is so liberal that it even allows plans to use mobile applications to deliver notices and disclosures. So, it's a real shift and an acknowledgement of the sort of modern state of communication in some ways. And there's some limitations, of course, still. So electronic delivery is allowed in two sort of methods under this notice. One is notice and access, and the other is email disclosure. One of the big differences for those who grappled with electronic disclosure in the past is how does this, as compared to the old DOL safe harbor, is that this rule does not require that plans analyze how the participants interact with their electronic system as a function of their job, or require that they consent to receiving the electronic disclosure. But there are still some requirements that you want to be mindful of before you just start shooting out emails to your participants. The first is that with respect to utilizing these electronic delivery rules, you have to notify participants by paper notice that their retirement documents are going to be furnished electronically. And that has to include a right for an opt-out. So individuals can still demand that their disclosures be made by mail. The Department of Labor made it very clear in the rule that this has to be in paper form, regardless of whether you are already relying on the old safe harbor. So if somebody's already getting electronic disclosures under the old safe harbor, you can't give them the notice of availability electronically. You will still have to do that by paper. So, we're talking mailings here. The initial notice of internet availability also has to include the email address, or if you're doing a mobile communication, the smartphone number that is going to be used as the primary delivery, which means this is not like under the old safe harbor, maybe a more boilerplate notice that can be distributed to everyone, in the sense that it will have to include individualized information. So you're going to have to make those changes to the notice, which may make it a little bit more challenging to put in place. But one good thing is that it doesn't need to be a standalone document. So you can combine this with other things. And you can also, under a special rule, allow certain documents to be announced in a single notice. So specifically, you can provide that notice for summary plan descriptions or other certain covered documents or information that's furnished electronically. Or, if we get additional guidance from the DOL or IRS, we can combine more things there. I'll note SMMs cannot be included in that notice, and even though the SPDs can, and the pension benefit statements we were just talking about a minute ago wouldn't be able to be covered in that. If you basically would provide this annual notice like at least once every more or less year, but technically every 14 months to cover those. Otherwise, a separate annual notice has to be provided for the documents if they're not covered by that special rule. For this new electronic delivery rule, you can't use it for everything, but it is allowed to be used for anything that must be provided automatically under ERISA, and that includes some of the notices listed here. What I'll mention is, the automatically is mentioned here because it does not apply to participant requests for documents. So if you're getting any requests for an SPD or any sort of one-off type request, those would not be covered. It also doesn't apply to notices required under the Internal Revenue Code. So automatic enrollment notices, safe harbor notices, QGSA notices, 204H notices, notices like that would still be subject to the old 2006 IRS rules. I will say that the guidance from the Department of Labor basically anticipated that there would be further guidance from the IRS and coordination to ensure that there was some consistency here, but we've yet to see any of that guidance. So right now we have a couple of different standards. So, even if you are going to take advantage of the opportunity to use electronic delivery, it's important to make sure you're in a position to properly provide these notices or notices of these notices by mail. Next slide, please. But with respect to the delivery of these notices, so when you are distributing the notices to participants, it's a natural opportunity to take a look at your plan data. And I think Mike's gonna talk about that a little bit more, but there's a continued focus from a regulatory perspective on ensuring that participants are being reached, whether it's for their benefit commencements, whether it's for their notices. Ultimately, to ensure that you're complying with these requirements, you have to be able to reach participants, including, again, by mail in some instances. It does take time to clean up the data, and the better thing, because again, it's sort of the season, we would recommend typically allowing like a month to really go through and make sure you have the proper addresses before you send all these notices. What we're seeing is, continued audit activity by regulatory agencies that, this could be incorporated into some level of response to. And so if you're showing that you have a good process, like doing these sorts of data sweeps and cleaning up that data before you send regular notices, you can, help defend your practices to the DOL and IRS. But there are also a lot of other fiduciary considerations that make it really important to make sure you're not sending these notices to the wrong place. Ultimately, you have a duty under ERISA to give these notices. But you also have, the concerns with respect to account theft and benefit theft and identity theft that you need to prevent if you're acting in the best interest of participants and beneficiaries. And so making sure that you're doing these searches and you're not sending notices to the wrong place, like you would hate to send a pension benefit statement to the wrong address, which I guess I'll mention, by the way, on the pension benefit statement, the electronic delivery requirements actually made it a little bit harder to provide electronic delivery because you used to be able to just have it online somewhere. Now you can't continue to do that. You have to provide the quarterly notice, or the notice of availability. So it's going, there are some, in some ways the notice is more helpful, in some ways it's less. And so you want to make sure that you can reach people so that you don't have any risks of that theft. The Department of Labor has been doing audits on this topic as well. And so particularly like cyber compliance. And I know PBI has done other learning series on this. So I won't spend a lot of time there, but I think it's really important to keep in mind that, just because you're using more electronic communications doesn't mean you can avoid some of these issues from a data perspective. So with that, I think I will turn it over to Mike.
Thank you, Carly. Really appreciate it. I want to just touch on a little bit of what Carly said and maybe expand on it a little bit. She had mentioned about proper notice to get these letters out. We do hundreds of thousands of these letters for pension funds and other funds of that nature. And when we talk about time period and length of time to be able to get those out, we're really looking at 30 to 60 days. A lot of that is with data cleanup, but we try to avoid these rush jobs where people are coming in where they have to get it out within 2 weeks, and we're quickly trying to clean up the data the best we can. So a 30 to 60 day window would be very appropriate. Carly also touched on email. I know that's something we're looking to incorporate in our locate package as well for sending out information to the plan participants. But to touch on the data cleanup, we really look at it 4 areas. Social Security number being the biggest one. That's the biggest and most severe. When we talk about data cleanup, we want to make sure that Social Security number is correct, because if it's not, we're going to have a difficult time in making sure that we get an updated location or an updated name. A lot of times we see a Social Security number mixed up in a plan sponsor's database where the SSN is for the spouse and not for the participant, or it's for a child and not for the participant. So we really like to get that cleaned up, and to the extent that somebody has already passed away, it makes it more difficult for us to find that as well. Also, the impact of first or last names. Obviously, you want to get the right name to on the letter to go out to the participant, more likely that they'll receive it, that they'll respond to it. So getting that cleaned up is really important as well. And again, that's where you come up with the spouses and children names mixed up. But if we have the proper SSN, we're able to clean that up. The date of birth, it's helpful in that it's easy for us to kind of locate when maybe a planned sponsor has bad data, where if the name is slightly incorrect or even the same, a lot of father-son instances where the date of birth is off, we like to clean that up as well. But then addresses, that's the biggest one. We want to have that time to update addresses. The average person moves every 7 years or so. So we're constantly, before every mailing, first thing we do is we run it through our database. We're trying to update names, dates of birth, socials, but most importantly, the addresses. And Carly touched on it. You don't want to be sending the letter to the wrong address. Person's moved, maybe it doesn't get forwarded, it comes back to us. So we want to make sure that we're getting these letters out to the right location. It's the easiest thing to do, but it's a step that you really have to be doing for all your letters before they go out. And I think we're close to time here, so that wraps it up for me.
Well, thank you, Mike, and thank you, Carly, for the presentation.
Oh, sorry, before you go, I just want to explain some of these predictions because these are the most exciting part of the whole thing. So really quickly, you know, I think the first couple aren't the most exciting because I think anybody who's been paying attention a little bit and anybody who's familiar with PBI is probably pretty well aware of how important it is to make sure you've got your missing participants under control because of the Department of Labor audits here. Those are continuing. I think they're not slowing down in what I'm seeing and what we're seeing here at Morgan Lewis. So, you know, keep doing what you're doing from a missing participant perspective, and just keep in mind not to set it and forget it. We're also seeing that the DOL guidance on cybersecurity is, of course, a hot topic, and it's getting tacked on to existing audits. And I think I've heard, in fact, it's becoming a policy. If you've got an outstanding audit and you haven't gotten a question on cyber yet, you should expect that you will receive one. IRS audits focusing on timely commencement are also continuing. I think they just kind of work their way down the list. We are seeing that those continue. And again, I think this goes hand in hand with making sure your people aren't missing because it's both a DOL ERISA fiduciary concern, but it's also an IRS plan qualification issue. You know, participant plan fee litigation is also something that is just booming. It doesn't seem to stop. I think we've had, you know, record-breaking numbers of cases and settlements. And in fact, there was an important Supreme Court case on Monday, or decision on Monday on this. So we should expect more of that. Communicating these notices and other materials to participants is going to be a really important part of ensuring that you minimize your liability for potential exposure to those types of suits. And then, you know, on the lifetime income disclosures we just talked about, right now we're operating under an interim final rule. So it may be that we get some sort of final rule or some DOL sub-regulatory guidance. That's kind of their favorite way to do things anymore as people start putting those out if there are questions and questions from participants, for example. And then finally, I would just mention, this is probably the most speculative of it all, but also not that, because it's the topic of new retirement plan legislation, which I think everyone's just kind of waiting for. You know, the question is really, is 2022 the year? And I think we thought there might have been something in 2021. I think everyone saw what happened to Build Back Better Act, but there is general bipartisan support for retirement legislation, and whether or not it involves you know, other types of topics that slow it down, like we saw with the Build Back Better Act, it kind of remains to be seen. But what I will say is, in most of the drafts of proposed legislation that we've seen, pension commencement dates are being changed and shifted out a little bit later. So that's something that you should expect to see. And there's also usually some focus on penalties and other things. So it's really just important to keep your house in order to avoid, you know, any implications there down the line. But we shall see what they include for 2022.
Great, thank you, Carly. I think this is always the piece where sometimes it is speculative, but I think it's a lot of that writing is on the wall. Well, I'd like to thank everyone again for joining us. We are at a little past the top of the hour, so we want to be conscious of everyone's time. If there are additional questions that you have, either regarding the presentation that we just went through or around PBI or Morgan Lewis, our contact information is noted as well. We'd be more than happy to have a conversation and talk through either the services that PBI has to offer.